According to victims who cooperated with the FBI in that investigation, these documents in FBI possession, your possession, detail at least 20 men, including Mr. Jess Staley, CEO of Barclays Bank, who Jeffrey Epstein trafficked victims to, victims including minors such as Virginia Roberts Giuffre, may she rest in peace. That list also includes at least 19 other individuals, one Hollywood producer worth a few $100 million, one royal prince, one high-profile individual in the music industry, one very prominent banker, one high-profile government official, one high-profile former politician, one owner of a car company in Italy, one rock star, one magician, at least 6 billionaires, including a billionaire from Canada. We know these people exist in the FBI files, the files that you control. I don't know exactly who they are, but the FBI does.
When Kash Patel took office as FBI director, he made a public commitment. The Jeffrey Epstein files would be fully released. Months passed, but the questions in Congress did not stop. What was being debated that day was not who Jeffrey Epstein was. What was being debated was the status of the information in the FBI's possession, and why the public still could not access all the answers. What made it notable was that the questions were not coming from just one side. Republicans and Democrats, despite holding very different political views, thus arrived at the same point. They used different words, but they were all looking for the same answer. And that answer produced some of the most striking moments of this hearing.
Mr. Chairman, Director Patel, I watched some of your Senate hearing yesterday when Senator Kennedy asked you, you've seen most of the files, who, if anyone, did Epstein traffic these women to besides himself? You replied, according to the transcript, there is no credible information that he trafficked them to anyone else. You also said somewhere in the hearing and here today that the problem is that the case files are constrained by limited search warrants from 2006 to 2007 and that the non-prosecution agreement hamstrung future investigations. Those constraints only apply to Southern District of Florida. They do not apply to Southern District of New York, the location of the 2019 sex trafficking indictment, which produced many things, including a series of FD 302 documents. According to victims who cooperated with the FBI in that investigation, these documents in FBI possession, your possession, detail at least 20 men, including Mr. Jess Staley, CEO of Barclays Bank, who Jeffrey Epstein trafficked victims to, victims including minors such as Virginia Roberts Giuffre, may she rest in peace. That list also includes at least 19 other individuals, one Hollywood producer worth a few $100 million, one royal prince, one high-profile individual in the music industry, one very prominent banker, one high-profile government official, one high-profile former politician, one owner of a car company in Italy, one rock star, one magician, at least 6 billionaires, including a billionaire from Canada. We know these people exist in the FBI files, the files that you control. I don't know exactly who they are, but the FBI does. Have you launched any investigations into any of these people, and have you seen these 302 documents?
Sir, I have asked my FBI agents to review the entirety of the Epstein files and bring forth any credible information. And we're working with Congress not only to divulge that information and produce it to you, but any investigations that arise from any credible investigation will be brought. There have been no new materials brought to me launching a new indictment.
So is the loophole here, or is it your assertion that these victims aren't credible, that the 302s maybe didn't produce credible statements that rise to a probable cause?
It's not my assertion, sir. It's the assertion of two different United States attorneys' offices from 3 separate administrations who investigated those same materials in live time.
Are the 302 documents in the FBI's possession?
They reviewed all that, yes, sir.
And so have you reviewed those 302 documents where the victims name the people who victimized them?
If I personally know, but the FBI has.
So how can you sit here and in front of the Senate and say there are no names?
I said all
I named one today.
One of the most critical moments of the hearing began with two consecutive questions from Representative Thomas Massie. The first question was straightforward. Did the FBI have FD-302 witness reports, statements in which victims named individuals by name during the Jeffrey Epstein investigation? Kash Patel's answer was clear. Yes. But the second question changed the atmosphere in the room entirely. Have you personally read those reports? Patel's answer was again brief. Have I personally? No. But the FBI has. It was at that exact moment that Massie posed one of the most striking questions of the hearing. If the FBI had statements in which victims named individuals by name, and if those statements had been in the agency's possession for years, then how was it still possible to speak as if there were no names at all? This was not merely a debate about unread documents. This was an examination of how much of the information in the FBI's possession had been reviewed, how much had been disclosed to the public, and how far the answers given to Congress aligned with those documents.
Move on here. Were you present when the AG had the White House event when she released the binders to the social media influencers?
I was, yes.
So if you're willing to meet with social media influencers who stood to benefit from the sensational and sad stories of these victims, will you meet with the victims as well?
The FBI will meet with anyone who has new information.
Will you personally meet with them?
The FBI and the professionals who are handling the cases will.
Were you instructed that it was important to release the documents to the Oversight Committee on the day of my introduction of the discharge petition to release these files?
I don't know what day that was, so no.
Well, they were released that day, and there were victims' names who weren't redacted because they were in such a rush, and the victims are not happy about that. Have you investigated any of the CIA connections? Have you seen the CIA file on Jeffrey Epstein? And if you wanted to see it, would they show it to you?
Well, I can speak for the FBI, and that's presuming there's a CIA case file, and I've reviewed everything that the interagency, not I, the FBI, that was provided to us.
Would you be willing to look at the CIA file on Jeffrey Epstein?
If there is such a file, and if it has not already been turned over to the FBI will look at any new investigative leads.
Have you made any progress on the pipe bomb investigation January 6th? And have you made any progress on the motive of the Las Vegas shooter?
As to the first, it's an ongoing investigation, and we have made progress. As to the second, sir, I'll have to get back to you.
Thomas Massie was a Republican. He broke with his own party's leadership to support the Epstein Files Transparency Act. That day, he questioned FBI Director Kash Patel directly. His questions were clear, but he did not receive the answers he was looking for. Nearly 3 hours later, a Democrat from the other side of the chamber took the floor. Representative Dan Goldman picked up exactly where Massie had left off. The files were the same, the questions were the same, and the answers given, rather than closing the debate, only deepened it. This is how one of the most direct and pointed confrontations of the hearing began.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited
Wrong.
in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that. There are sealed court order documents. There are protective orders.
They are unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay, well, you agree that there are, so your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, all of the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims, but if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it
And
exists,
so why haven't you released it?
why are you supposing that that is a fact when in fact it is false? Are you saying that
You're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the sex ring that you promised to do before you became FBI director.
I just told you, I'm not going to release downloaded porn of
I'm
children
not asking
on the
about
internet.
that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our
I
possession.
understand. And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you, in that stuff, there's nothing that's related to to any other sex traffic, any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay.
Throughout the morning, Kash Patel grounded the FBI's position in court orders. But Dan Goldman interpreted the same legal framework in an entirely different way. According to Goldman, who had served as a federal prosecutor for 10 years, the court orders Patel was relying on were no longer in effect. Patel's response came without hesitation. That's just not true. What followed turned into a confrontation in which not only the documents, but the interpretation of the law itself was being challenged.
No.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to
How
the
is
courts.
how is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders
Actually,
work? Do you know how
Mr.
sealing
Patel,
orders
I was
work?
a real prosecutor for 10 years. I know exactly how
so I was a
court
fake one?
orders. And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless
So
that
your
judge
testimony
waives
here
it.
is that all of those witness statements are under a court order, a protective order.
We are providing everything we can legally provide.
No, that's not my
Congress has
question.
sent us a
My
subpoena.
question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not
And
under a protective
Why
order?
are you not going to the court like you did for the grand jury testimony to unseal those
The
records?
DOJ did go to the court.
No, not on those records. Why
Time
aren't
of
you
the
going? You
gentleman.
just went on grand jury.
Time of the gentleman has expired. The
You are hiding the Epstein files,
time
Mr.
of the
Patel.
gentleman has expired.
You are part of the cover-up.
Can I respond?
Sure can.
Any allegations that I'm a part of a cover-up to protect child sexual trafficking and victims of human trafficking and sexual crimes is patently and categorically false in the work of my
So I hope you will talk to them when they
Gentlemen's
have
time has
requested
expired.
to speak with you. Because the
Gentlemen's time has
victims have
expired. Gentleman
requested
yields
and you are
back.
not responding to them.
At the end of a hearing that lasted nearly 5 hours, Kash Patel had answered dozens of questions. He confirmed that the FBI holds FD-302 witness interview reports. He also confirmed that he had not personally read those documents. Throughout the hearing, both Republicans and Democrats returned to the same files from different angles. Some asked why the names had not been released. Others questioned why the promised transparency had not yet been delivered. The answers given did not close the debate. They gave rise to new questions. Even after the Epstein Files Transparency Act came into force, these discussions continued. At the time this hearing took place, the process of releasing the files to the public was still at the center of the national conversation. All footage and statements in this video are drawn from publicly available congressional records. We only examine the official record, provide context, and present what was said as it was said. For analysis of this and similar official hearings, subscribe to the News Desk USA.